Good afternoon, everyone, and thank you for attending our employment update for franchise systems. We hope this will be an insightful session as we focus on the key changes to UK employment law following the introduction of the Employment Rights Bill and how issues arising in franchise systems can or will be impacted by the ERB. We will also explore best practice for how franchisors can support or manage the implementation of these changes in respect of their franchisees. So before I pass you over to Gordon and Alex, who are co-hosting this session, I would like to just briefly introduce myself and tell you what we'll be doing in today's session. So my name is Sarah, and I'm a senior associate in the commercial IP team, and I'm based in Manchester. I've been over 10 years of experience in advising predominantly franchisors on various aspects of franchising, which includes domestic and international. So in terms of the session today, I just want to remind you that this session is for 45 minutes and will be recorded. We do want this session to be as interactive as possible, so we do encourage that you ask questions throughout the session by using the Q&A box. I have been given permission by Alex and Gordon to interrupt them with questions. However, if I don't get the chance to ask every question, please be assured that one of us will follow up after the session with a response. Please can I ask that you refrain from putting questions in the chat box as this session is intended to be anonymised and as mentioned before is being recorded. So Gordon, over to you.
Thanks very much, Sarah. So just by brief way of introduction, my name's Gordon Drakes. I'm a partner and co-head of the franchising team at Field Fisher. And just to kind of put a bit of framing around the context of today, the intersection of employment law and franchising has certainly been front of mind in some important franchising jurisdictions around the world, particularly the US, Canada, and Australia in the last few years, where the emerging concept of joint employer liability in particular has been the cause of much head scratching and litigation. In the UK, the legal landscape is comparatively benign, but as we enter 2025 with a new Labour government, employment law is very much back at the top of the agenda. And from the 1st of April this year, many businesses are already feeling the cost pressures of rises in national minimum wage and national insurance contributions, but that is really just the start. The Employment Rights Bill sets to shake up the employment landscape over the next 2 or 3 years. And I'm delighted that we're joined today by Alex Watson, who's very kindly agreed to join us and discuss some of the key issues for franchise systems. So over to you, Alex.
Great. Well, many thanks, Sarah and Gordon, and everybody for attending today. The Employment Rights Bill proposed by the government is potentially, and I say potentially deliberately, one of the single biggest changes to the employment law landscape in the last 30 years or so. And as an employment lawyer, it's a really interesting topic to be asked to cover. And I could talk about it all day, but I promise that I'll stick to a strict 45 minutes today. And as we see from this slide, the proposals in the ERB are wide-ranging and they're ambitious. And this slide summarises some of the main proposals which have been presented by the bill. And the reason that I mentioned that these are potentially significant earlier is because a lot of these proposals were rushed out at the end of 2024 in order to meet Labour's manifesto promises for reform within the first 100 days of power. So there are large parts of the bill that are subject to ongoing consultation, which we suspect will greatly water down some of the potential impact of the changes, and parts that simply don't feasibly work at the moment. But what's most interesting about these proposals is the scope and ways in which they'll impact different sectors, business types, and models. And franchise businesses in particular will need to consider whether these proposals present need to review franchise agreements and operating manuals, and whether or not these changes have a greater impact on franchisee compliance and how it might impact the underlying brand, particularly in light of the recent situation where we've seen franchise operators such as McDonald's select committees. So there's been a lot of press about the introduction of day one unfair dismissal rights, but to an extent, that's a bit of a red herring and a distraction from some of the more impactful parts of the ERB proposals. So due to the time constraints, I'm going to touch on a couple of the less discussed parts of the ERB, which I think are likely to have a really big impact on franchisors and franchisees. And the first point of interest relates to changes in discrimination law and employers' duties to prevent the harassment of individuals. So by way of a very brief refresher, harassment arises where a person engages in unwanted conduct, which is related to a protected characteristic, for example, age, sex, or race, and this conduct has either the purpose or the effect of violating that person's dignity or creates an intimidating, humiliating, hostile, or offensive environment. So it's generally a pretty low bar for individuals to meet, and it relates almost entirely to the impact on the individual rather than the intent. And harassment also includes sexual harassment, where the harassment in question is of a sexual nature, or where individuals are subjected to unfavorable treatment if they reject or submit to unwanted sexual conduct. Now, at present, these protections only protect individuals from harassment committed by other employees, workers, or contractors of their employer. But as we've seen the first changes in the law on harassment come into effect from October 2024, and I'm sure that everyone on this webinar is aware that the law was changed to require employers to take reasonable steps to prevent harassment of staff, or sexual harassment of staff, I should say. The ERB first proposes to amend this to increase this threshold to take all reasonable steps, a higher threshold for compliance with discrimination law. But the really big change here is the middle bullet point, particularly for franchises and any businesses with public-facing operations. And this is the increase of the scope of liability for harassment of employers to the actions of third parties. And this won't just be sexual harassment, but that harassment could be related to age, to sex, disability, sexual orientation, any of the protected characteristics. And this harassment might come from a member of the public, it might be a supplier, it might be a franchisee speaking inappropriately to a franchisor's central team. So the scope of this is huge. And the effect of this change will be to make the employer of the individual liable for harassment carried out by that third party. Some people on this webinar may recall when third-party harassment was prohibited previously, but the risk and the thresholds for employers here is likely to be high. So under the bill, there's going to be no requirement for the individual to have been harassed on at least 2 occasions, or for the employer to have had knowledge of the harassment. It will be down to the employer to have anticipated potential risks and put in place systems and mechanisms to prevent it from happening. And again, this is likely to be an obligation to take all reasonable steps to prevent that from happening. Finally, touching on that last bullet point, currently sexual harassment complaints can be protected disclosures where they meet the public interest test and they're considered a breach of health and safety or a breach of a legal obligation. But the bill also adds disclosing sexual harassment to the list of what can count as a protected disclosure, making it more explicit that this can amount to whistleblowing as long as it meets the public interest disclosure test. And this change will open up the possibility of things like interim relief for employees who are dismissed when making complaints about sexual harassment, as well as other reputationally risky claims that may need to be disclosed in tenders or ethical chain audits. Now, I've started on this point because this is more of an evolution of the existing law rather than other areas of the ERB, but it's going to present some challenges for all businesses, and it will justify businesses carrying out a full review over the course of 2025 in advance of most of these changes likely taking effect in 2026. And whilst this places a more onerous duty on employers, following the changes in October 2024, it might be a relatively simple exercise to expand risk assessments that may currently be in place for sexual harassment to other types of harassment. It's going to be interesting, and when I say interesting, I mean potentially concerning for employers to see how the law adapts to this change for individual circumstances. So, for example, what if a customer includes an offensive name on a coffee cup order or in the comments section of an online order? What's a reasonable step that either a franchisor or a franchisee will be expected to have taken to prevent that from happening? And where will the line be on what's reasonable? And particularly from a franchise perspective, whilst this liability will ordinarily sit with the direct employer, the franchisees, we've seen McDonald's executives being summoned to select committees earlier this year in response to sexual harassment allegations carried out in stores that were under franchisee ownership. And these changes in the law and the increased risk to brands will naturally require franchisors to think about how to maintain independence from franchisee operations so as not to open the door and the sort of arguments that Gordon's touched upon about joint employments we're seeing in the US or being named as a party in tribunal proceedings, but also ensuring that senior management of franchisor businesses and the brand itself is protected from demonstrating that it's done all that it can to enforce compliance with these obligations through its franchisees. Next up, it's worth highlighting some of the changes around trade union rights and membership. The ERB is going to bring in some really interesting changes regarding the rights of trade unions and the obligations of employers. And some of these will be straightforward and shouldn't be a real cause for concern. For example, there will be a requirement for employers to include a statement in contracts of employment reminding individuals of their right to join a trade union. Fine. Likewise, there are going to be some favourable changes for trade unions, which will include recognition rights and taking industrial action. And under the proposed bill, for formal recognition, the requirement to show at the application stage that at least 50% of workers in the bargaining unit are going to support recognition is going to be reduced to 10%, with potential for that to reduce down further to 2% in the future. And it will also simplify the support required for recognition in a final ballot, so that a simple majority is required. Likewise, for industrial action, the notice periods unions will be required to give to employers for industrial action will be reduced from 14 days to 10 days, and the mandate for that industrial action will be extended from a 6-month period to a 1-year period. And that will reduce the need for frequent reballots and supports longer-term industrial action where necessary, which means that employers may face longer periods of potential industrial action without the need for ballots. However, one of the most interesting but under-mentioned parts of the ERB is this second bullet point, which is the right for trade unions to access workplaces. And this is a brand new right that will permit trade unions to request an access to the workplace agreement from employers to provide physical and potentially also electronic access to meet and recruit new members, encourage membership, organise workers, support a member with an employment matter or for collective bargaining. And what's most interesting about this proposal, and which may well be watered down, is that this right does not only apply to trade unions that are recognised by an employer, it will potentially cover all of the trade unions recognised in legislation. And it's not yet clear whether or not this will still apply even if an existing trade union is recognised. And at the moment, the only guidance we have on when a request for access from a union could be refused is where it's reasonable in the circumstances to do so. And employers who fail to comply with those obligations will face fines. So what this could theoretically mean in practice is that multiple trade unions demand physical access to sites and stores. And it's going to present challenges for all businesses, but franchise operations will have some unique considerations. So how and where would small sites be able to accommodate a trade union visiting a site? What if the only space is going to be customer facing? Are there any alternatives that the franchisor could offer to a franchisee to help them comply with these obligations without damaging the brand? And additionally, unlike other business models, franchisees and franchisors may face competition from multiple trade unions trying to fight for recognition across an estate. So, for example, imagine that coffee shop X has a mix of self-owned and operated stores and an estate of 200 franchise stores. Multiple trade unions may fight to be recognised across that franchisee estate without the franchisor being aware, and then use that knowledge to make inroads into recognition with the head franchisor. Likewise, would the same trade union being recognised for some multiple franchisees make industrial action more likely if that union is aware of the terms of the franchise and it knows that another franchisee pays its employees at a higher rate of base pay or overtime? And this is going to be one of the most interesting proposals because its take-up and its impact is unknown. It's potentially highly disruptive if adversarial trade unions push for recognition and agitate, and it may trigger some left field strategies which particularly employment lawyers wouldn't typically advise, such as franchisors and franchisees voluntarily entering into sweetheart deals with friendly trade unions to reduce the risk of a trade union scrap for recognition. These changes are subject to consultation, and they're not expected to come into force before autumn 2026. So 2025 will be the time to consider how this increased union activity might impact both franchisors and the franchisees. The Employment Rights Bill also introduces several changes regarding zero and minimum hours contracts and shift cancellations to protect workers with unpredictable working patterns. The government has proposed that many of these changes for minimum hours workers will begin consultation in 2025, and that reforms will come into effect no earlier than 2026. But these proposals are very much in their early stages, as we'll discuss when we talk about some of the reasonableness provisions, which make these quite difficult provisions to understand what the impact might be. But the first significant change is the guaranteed hours provisions. So minimum hours workers, for example, those on a 0 hours or a minimum of 10 hours per week contract, but who regularly work more than the minimum in their contract, will have a right to be offered a guaranteed hours contract reflecting the actual hours that they routinely work. For example, a 0 hours worker who routinely works 40 hours per week over a set reference period will have the right to be offered a contract guaranteeing them 40 hours per week. And this may be fair and a sensible approach to giving individuals security, but it's also going to present some potential problems for employers particularly employers such as smaller franchisees who don't have sophisticated or dedicated central teams, such as HR and dedicated payroll teams. And this is largely because it's anticipated that the obligation is not just to permit the individual to have guaranteed hours, but for the employer to offer the guaranteed hours contract. It's currently anticipated that the set reference period will be 12 weeks, and it's expected that every 12 weeks, the employer will need to review and check the hours worked by any minimum hours worker, and then to proactively make the offer of that new contract to the worker. And this can be administratively burdensome, particularly as there may be workers on different 12-week reference period, and it's not yet known what working regularly more than their base hours actually means. For example, would one significant week of shifts at a seasonal pinch point count as regular? What if it's only 2 weeks out of the 12? What if there's a need to average the hours over this period? And if so, how do we calculate that average? And a further potential issue that's not yet been addressed is how seasonal pressures will impact these new provisions. So for many businesses, summer holidays or Christmas rush will influence the need to flex staffing hours up and down, but it's not yet clear what would happen to minimum hours staff who would be entitled to receive a permanent contract change if a spike in labour requirements fell within this abnormal 12-week period. In addition to that, we've got a major change of a three-pronged change to shift changes and cancellations, which can be impactful. Firstly, reasonable notice of shifts. So employers must provide reasonable notice of any shifts they require a worker to work, and that includes shifts that deviate from the worker's usual pattern. Secondly, notices of shift changes or cancellations, and employers will be obliged to give reasonable notice for any shift cancellation or change to the day or time a shift is supposed to start or end. And what's reasonable notice will depend on the circumstances, but it's likely that we're going to see regulations over the course of the next year setting out what that minimum time period will be. And finally, payment for cancelled, moved and curtailed shifts at short notice. So employers are going to be required to give compensation to workers each time a shift is cancelled, moved or curtailed at short notice. And again, unfortunately, at present, it's unclear what reasonable notice will mean for employers in this context, and will undoubtedly get guidance. But again, for employers such as smaller franchisee operations, the risk of incurring fines and penalties to employees as they need to flex their staffing needs will present a real employment cost risk, and it's potentially going to remove a lot of the current flexibility available to employers. Again, thinking about it from a franchise perspective, franchisors will need to consider whether the terms of franchise agreements place pressure on franchisees which might cause them to breach these employment provisions, or which could expose them to significant additional employment costs if their labour modelling isn't right, particularly in conjunction with other rights such as changes to the SSP rules, which are anticipated soon, which may increase short-term sickness absence. So staffing modelling could become a really important factor. Although, interestingly, employers might be able to contract out of these guaranteed hours and shift notification requirements by using a collective agreement agreed with a trade union, which again may influence whether or not it'd be helpful to voluntarily recognise friendly trade unions. So franchisees and potentially also franchisors should consider now how the business and their brands currently handle staff flexibility and shortages. If there's regularly a requirement for staff to work longer, or employees are regularly told that they're needed for less time, how will franchisees manage these new provisions and costs? And are there any corrective or recommended steps that can be taken now in advance, for example, to make work patterns more efficient? As a franchisor, thinking about service and reputation of the brand, could any of these changes expose risk if it means that some franchisees could become insolvent? Or will the brand be damaged if KPIs can't be met?
So I've got a question for you, Alex.
Yes, please.
So, so how will this interact with the Consumer Rights Act, where a consumer could cancel a service with short notice? Would you be able to do the same to employees?
It's a very good question, and the answer is almost certainly not. That it won't interact in that way, which means that you're justified in doing it. And it's why this staffing issue is going to be one to start planning for ahead. I'm very much saying to employers at the moment, 2025 is very much the planning year, because if we know, or franchisees know, that actually this happens really frequently, that we see a big drop off in cancellation because that's a consumer's right, how are we going to handle it? Are we better off to keep people in work but underutilized, or do we stretch it by having fewer people in by factoring in that some people may cancel orders? It's going to be really hard because it's not going to be, or almost certainly not going to be valid for an employer to say, actually, we're justified in sending somebody home because due to circumstances outside of our control, there's less work for them to do. These rules are here to protect the workers and say, well, okay, that's fine. You guys are in business on your own right. They're an individual. They're small. You're big. They deserve to be compensated for being sent home. So this is why it's going to potentially be a really big issue.
Great.
I feel very much like a doom-monger today. And finally, I've saved what could be the biggest change to the end. And I'm not going to change my tone. The ERB proposes to create a new single enforcement body called the Fair Work Agency to strengthen the enforcement of workplace rights. And this will be a new state body consolidating existing state enforcement functions, such as minimum wage compliance, statutory sick pay, protections against modern slavery. But its scope will potentially also cover holiday pay. And in the future, it could cover things such as discrimination in the workplace. So some people on this webinar may have been subject to a national minimum wage audit by HMRC. And if so, they may understand why this is potentially one of the largest concerns for employers in the ERB, and which has not received much press to date, and certainly not as much as I would have expected. And in particular, this concern stems from the fact that if the FWA operates as the current national minimum wage HMRC compliance team operates, it will be judge, juror, and executioner in determining whether or not employers have breached obligations to individuals, with the ability to order payments to employees and penalties to be imposed. So current guidance suggests that this may not be the case, but the major concern here is that this won't require the employer to be taken to an employment tribunal for these issues to be determined, but the FWA will have the right and ability to unilaterally make a finding, with the added risk that there'll be penalties payable to the FWA for breaches to employees as decided by the FWA alone, as happens with national minimum wage audits. And given that the government has indicated that the FWA will be self-funded, it seems a legitimate concern that penalties will be the way in which it becomes self-funded. So the risk here for employers is that it's likely that presumption of guilt will apply, as it does with national minimum wage record keeping. So if an employer can't demonstrate that it has properly paid its workforce, it's at risk of the FWA presuming that there's been an underpayment. And as an employment lawyer, I see on a daily basis the challenges that businesses face in calculating holiday pay, particularly for staff who work variable hours and rates of pay. It's a common area where mistakes can happen. So it's likely to be something that a lot of businesses are going to fall down on. And the prospects of employers being required to prove that payments of this type have been paid correctly over the past 6 years may be concerning, particularly for franchise operations with multiple smaller franchisee operations who may not have sophisticated central processes to accurately retain records and ensure compliance. And as with national minimum wage issues, it's unclear whether or not the FWA will publicly name and shame businesses that are found to have breached obligations to employees. But in particular, in a franchise model, that's likely to be a weapon to enforce franchisors to ensure compliance throughout their franchisee estate. So a balance may need to be struck between franchisors imposing stringent requirements to demonstrate compliance, such as audits, and the risk that, if unchecked, unsupported franchisees could incur significant financial liabilities to former employees and bring the brand into disrepute. And whilst that might seem like bad news, it is likely to be several years before the FWA is fully established, and it may yet be watered down. However, it is sensible for franchise businesses to consider what this enhanced record keeping and compliance obligation may mean for them. And in the case of franchisors, for their franchisees, what the correct level of support and guidance and step-in rights will be.
Great. Well, thanks very much, Alex, for that overview. That's very, very interesting, and a lot, I think, for franchisors and franchisees to consider. Just listening to you there, I think there's at least kind of 4 key trends, I think, that seem to me that are going to be emerging over the next few years. It seems likely that we're going to probably see more litigation in the employment space between employers and employees, whether they're franchise or franchisee employees. It's very interesting about trade union involvement, potential greater involvement of trade unions within franchise networks. Definitely more cost. We've already seen that with some of the cost introductions of the 1st of April, but that overall administrative burden and compliance burden that's going to come down the line, I think is just going to add costs, extra costs into franchising businesses, which is going to create a number of other challenges. And also that audit risk of government intervention as well, and inspection. So a lot to consider. So really, I think for the next few slides and for the remainder really of this webinar, what we wanted to do was have a bit of a conversation with you, Alex, and indeed ask our audience to to ask questions as well about the different types of potential approaches that franchisors should consider taking in this new landscape to get ahead of some of these issues, and some of the risks or benefits associated with that. But before we do that, I think it'd be worth just taking a step back and considering from a kind of a UK franchise agreement standpoint, what does a typical franchise agreement currently say in respect of employment law issues, and what doesn't it say? So if we can kind of understand that, then I think that will lead us into the conversation about some of the potential approaches and risks and benefits. So if I may, just for a couple of minutes, on that first slide, this is just us looking at some samples of kind of typical unit franchise agreements in the UK and some of the common terms you see. So bullet pointed on the slide in the same order would be that you'd typically see that franchisees themselves are under an obligation to ensure that their own employment contracts comply with applicable laws, and that those employment contracts with their own employees protect the franchisor's intellectual property and confidential information. Training is often a key term that you would see, so that franchisees and their employees have to undergo franchisor initial and ongoing training. And actually the continued employment of those individuals is conditional upon them completing and passing those training modules. It's very common that a franchisee would nominate a key person, which would be the principal day-to-day contact between the franchisor and the franchisee entity. But that individual is often approved in advance of the franchise agreement being entered into, and any replacement is also then agreed by the franchisor. And that individual is often a director or sole or majority shareholder in the franchise business. And they may well also sign a direct undertaking with the franchisor in respect of confidentiality and non-competition. Thirdly, often there's a catch-all provision around reputational damage. So often franchisees will agree that they will be responsible for the conduct of their employees to make sure that they're behaving appropriately, and that they should notify the franchisor of any issues created by their employees which are not doing that, and that they need to obviously maintain sufficient staff levels in order to operate the business correctly. And then finally, some agreements, but this is probably getting into the minority, but still something we still see a bit of, get into a bit more detail about specifying certain roles within the franchisee business, certain roles of employment that the franchisee must employ within their business, and even going so far as to say what type of wage bands they should be offering, so that when it comes to recruitment of a brand that franchises, particularly where you've got a franchisor that's operating their own businesses, their own sites as well, there is at least to the public some consistency in the employment offer to members of the public that might consider applying for an opportunity with that brand, although their employer might be the brand itself or it might be the franchisee. So that's a snapshot of kind of what we see on the contractual side. And then if we just look at the next slide, just very briefly, the things that we don't see, but are, I think, following from what you said, Alex, things that we might want to consider going forward are whether or not franchisors should mandate particular HR providers, whether or not, whether the system should all be using one particular HR provider to help them deal with this administrative burden, particularly in relation to the hours and shift cancellation issues you were talking about. Another point we don't commonly see is that franchisors would mandate that franchisees use the franchisor's own employment contract templates or their own grievance policies or their own procedures. So they don't mandate that franchisees have to use that within their own business. And I think there's probably some good reasons for that, which we'll get onto in a moment. And then finally, audit and reporting. Again, typically in a franchise agreement, they tend to be limited to financial and operational aspects of the business, but they don't really extend, certainly expressly within the agreement, to kind of HR employment issues, such as the like we've been talking about today. So if we just look at the next slide. what's the best approach? So when the three of us were preparing for this, these are the kind of the three kind of broad categories that we were considering. So first off, you've got what we call the hands-off franchisor. So that's very much taking the view of franchisor, franchisee, independent businesses, franchisor, running their business and their employees as they see fit, and asking the franchisees to do the same, but not really having much involvement in what the franchisee does, other than just that general obligation that the franchisees have to comply with applicable law. The middle ground is the kind of the helpful franchisor. So that might be where a franchisor shares the kind of best practice that they're using within their own business in respect of their own employees. So they might make that content available. They might provide some training to their franchisees, but very much in a helpful guidance way, not mandating that, but saying, look, if you would like to have access to what we use, what we've invested in, this is what we do, but ultimately it's your responsibility to if you want to use that within your business, you need to take ownership of that and roll that out as you see fit. And then thirdly, we've got what we call the controlling franchisor, which is kind of the name suggests, is being much more prescriptive. So franchisors may well say, they want complete consistency across their network, whether it's a franchisee store or a franchisor operated store, that all employment contracts look the same, policies are the same, that there's just much more greater consistency, and the franchisor themselves might have a much greater role in terms of auditing franchisees to ensure that those standards are complied with within the network. So if that's kind of the broad scene, Alex, if I could throw it back to you first, but before we get onto the next slide where we've got some real life scenarios and questions which we could dig into you with. First of all, any particular thoughts or comments on the approach and kind of where you kind of currently think franchisors might be best to align themselves?
Yeah, and it's a really interesting question, and probably the $1 million one at the moment. And it will hopefully comfort people when we come on to talk about the US and the Australian model versus the UK position legally around franchisors and franchisees. And I'm going to give the short and possibly unhelpful answer that it's a bit of a balance, because the more controlling and directive franchisors are, the greater the level of responsibility and the greater the level of risk of being drawn into disputes and some potential legal battles, which really otherwise would sit with the franchisee. So a lot of that risk can be mitigated in franchise agreement terms, such as indemnities, which we'll have in place. There can be a risk sometimes in knowing too much. And equally, franchisors want to avoid select committees and reputational damage by holding their hands up and saying, well, we didn't know this was going to happen. But there is a risk that if we are too directive and we ensure that franchisees must use the same contracts, if they must use the same documents we mandate, if any of those documents are challenged by employees of the franchisee, or it's alleged that they're discriminatory, there's a risk that because we've imposed those as franchisor on the franchisee, that we could get drawn into litigation around discrimination or potentially also whistleblowing. Because whilst the franchisor won't necessarily be the employer, if they have instructed or caused the franchisee to implement a discriminatory term, for example, then that liability will potentially also sit with the franchisor. So being too directive and too rigid in directing franchisees has some risks to it. I think my suggestion would be the middle ground of being the helpful franchisor, because what franchisors will want to do is to be able to demonstrate, and I say this in the context of select committees, that we care and we put meat on the bones to what we say in our franchise agreement about ensuring compliance with employment law and all the other laws that we mandate in our franchise agreement. That if we have tools and resources, but we don't mandate that they're used, so for example, sample policies, sample contracts, legal updates, some providers, or we're signposting franchisees and people towards areas where they can meet these obligations, that's going to go a long way for us in our argument, if ever we needed to have it, of saying, look, we're not responsible for implementing these, but we have taken a responsible approach in the way in which we've signposted and we've tried to help our franchisees comply and meet the obligations in their franchise agreement. So my summary position is somewhere between the helpful franchisor with a bit of directive at times.
Okay, thank you. That's helpful. If we look at the next slide, then we've just bullet pointed down some real life issues that we've come across, we've read about, or we've had clients actually ask us particular questions about. So if we take it from the top, I think some of what you said is already touched upon the first one, but what type of liability does a franchisor open itself up to when providing samples of policies, procedures, employment contracts? That's, as you were saying, Alex, am I correct about if if there was an issue with those kind of procedures that they'd asked the franchisee to comply with?
Yeah, primarily it's going to be if we mandate policies and procedures that are used quite frequently, and we're seeing a big spike at the moment in tribunal litigation around discrimination. If it's alleged that any of those policies are inherently discriminatory, then we may well get dragged in as the franchisor. Equally, the more a franchisor has their fingerprints on things, from an operational perspective, even if there's no real basis to bring a claim against the franchisor, an individual will see the name of their employer, the franchisee. They will also see the head franchisor brand, and they will drag us into it because they will see that these documents have come from us. So there is an operational risk that you get dragged into litigation that you really have no part in, but it can often be quite time consuming, expensive to get out of it. And whilst we can have some indemnities in the franchise agreement, it's often a case of, well, are we really going to be able to recover those, or do we want to try and recover those from a franchisee?
Okay, that's helpful. And then the next one was on the subjects of joint employer liability, which I mentioned at the beginning. So anyone that's been involved in franchising in the US or has spoken to US counsel, that is kind of seen as an existential issue for franchising in the States, and it's kind of spread north of the border to Canada, and then it's gone over to Australia as well. And I think roughly in that sequence. And that started, my understanding is it started in the US with an issue around McDonald's, where there was a trade union involvement with a franchisee. There was some issues around minimum wage payments not being in compliance with the relevant state laws. Franchisee employees started to protest in the parking lot of a McDonald's restaurant. It got press coverage, and McDonald's, the brand, lent heavily on the relevant franchisee employer and said, you need to take action against those employees because this is very brand damaging. To which the franchisees, with the help of a labour union, were able to turn around and claim unfair, I guess the equivalent of unfair dismissal in that respect, and claim that both the franchisee and McDonald's Corporation were the joint employer for them, and that they had a claim against both of those companies. And that has then germinated and developed into various different types of laws around the US. So that's a big issue for franchising and kind of the home of franchising. Any risk of that? Any whiff of that here under the ERB?
Not under the ERB. And the good news is that in the UK, it's highly unlikely that franchisors will be held to be the employer of franchisee members of staff. So UK employment law will generally only establish an employment contract where it's absolutely necessary to do so. So if an individual's got a contract of employment with the franchisee, an employee would have to go a very long way to persuading a tribunal that it's necessary to imply that they're employee of the corporate franchise. And the law recognises that franchisors and franchisees are separate legal entities. So unless that franchise arrangement was seen as being a sham, the risk of being found to be an employer is pretty low. And that's good news at the moment, but the ERB may be a bit of a gateway. And we've seen a little bit from some of the highlights, if that's the right term, from the McDonald's Select Committee, of the struggle that the Select Committee and the law has at the moment between wanting to hold the bigger corporate party to account, even though there is no real legal mechanism to do so, because when it comes to employment rights, it will be down to their individual franchisee employer.
Sorry, I think, do you want to mention the third point there?
Yeah, so in Australia, there is actually statutory liability existing in the Fair Works Act for franchisors. And that's if the franchisees breach the law and the franchisor knew or could reasonably expect to have known about the breach, unless they took reasonable steps to prevent the breach. So we've seen this being illustrated in the 85 Degrees case. So this case involved a franchise of coffee shops that faced multiple investigations by the Fair Work Ombudsman. And this was over a 10-year period, and covering violations of employment pay awards under the Fair Work Act. So despite being notified of these contraventions and conducting audits, 85 Degrees did fail to take reasonable steps to prevent further violations. And the courts did find that 85 Degrees had significant control over its franchisees' operations, making it liable for their actions. And as a result, they were penalised and they were fined over 1.4 million Australian dollars. So I guess the question for you, Alex, is there anything comparable under the ERB?
Again, this is where I get to give my good news section of the webinar today. No, there isn't. But as I say, this is scope that this could be the start of change on that front. So there isn't anything in the ERB which would make the franchisor liable for the actions of the franchisee. It still very much looks at purely the employee and the employer relationship. It doesn't take into account potential franchise aspects of that. I suspect that at least initially, if state bodies like the Fair Work Agency want to try and hold franchisors to account at the corporate franchise, it will do so through things like name and shame and the sort of brand damage that things like select committees will do. So it won't be a statutory process. If I think about it very creatively, there are probably some ways around that individuals could try and bring claims against the head franchisor. But at the moment, there's nothing from a statutory perspective, which means that the head franchisor would be held liable. But this may be the direction of travel. But for the time being, there's nothing in there which would convey that liability onto a franchisor.
Good news.
Good. Just conscious of time, but there's just one question at the end of that slide I think might be worth mentioning, just on the whistleblowing point, which was a question we had from a client recently. So if a franchisor receives a whistleblowing complaint, for want of a better word, from the employee of a franchisee in respect of that franchisee, what should a franchisor do?
And this is a really tricky question because it comes back to that point of sometimes knowing too much can be problematic. And it will very much depend on what the whistleblowing policy will look like. So we know that some franchise operations, the head franchisor will operate a whistleblowing hotline and may sometimes be informed of that about issues that are affecting employees employed by a particular franchisee. There is the risk of that merging of and blurring of the lines between franchisee and franchisor. But as we've seen from McDonald's and increasingly courts and tribunals, and it is one of those areas where third parties like a franchisor can be dragged in to subjecting somebody to a detriment. And a franchisor could be the right person to report legitimate whistleblowing concerns to, that if that does exist, and it may be wise from a helpful franchisor perspective or even in the directive perspective to have that in place, that if we are made aware as franchisor about whistleblowing complaints, that we do take action with it. Now, each franchisor might have a different policy or set process for how they will operate that, whether it's sending it out for external investigation, whether it's notifying the franchisee, whether it's doing something different. But sitting on it is the sort of thing which is going to get us into brand difficulty, even if it's not necessarily liability, but it could still result in liability rising.
Yeah. Thank you, Alex. So I guess in summary, there are some practical tips which we've put up here on the last slide. So just in summary, consider being the helpful franchisor. But obviously, if you are being helpful, be clear and sure that what it is that you're providing to your franchisees is itself compliant. And if you're nominating suppliers, make sure that they're vetted and they're providing a good service. I think certainly from what you said, Alex, it seems that providing regular updates to franchisees over the next 12 to 18 months about all of these changes, because it is quite fluid and things may change, things may get watered down, but franchisees are going to need to know about this, and there's a vested interest for everyone in the network to stay ahead of this. So regular updates, developing a resource bank of policies, training, potential sample contracts or policies, I think would be useful. Having that sit alongside the manual, think about how that's made available to franchisees would be useful. Reviewing franchise agreements in the manual, think about where you currently sit on that spectrum of hands-off, helpful, controlling, and think about have you got the right balance at the moment, and are there gaps in your agreements and your manuals that you need to plug. I think the trade union issue is an interesting one for businesses to try and get ahead of when we know a bit more about that. And I think probably the last couple interesting as well. Definitely more cost and admin for the businesses. So when it comes back to selling franchises or looking at franchising on renewals as well, and you're doing your modeling, your business plan modeling with franchisees, this is going to have an impact on profitability. And so being and understanding that and keeping a watching brief on that, particularly if it's going to tip some franchisee into a financial distress situation, is going to be increasingly important. And then I guess if we're looking at a more litigious environment, thinking about how you as a network, both franchisors for its own employees and franchisees and their employees, whether or not there's a means to actually have a consistent approach or platform for dealing with employment tribunals. I don't know, Alex, whether you wanted to close by saying something on that last one.
Yeah, I think so. And where it comes to that helpful or controlling piece, I think having suggested providers or having uniformity that the entire network can come to is going to be really important from a brand protection perspective, because what may be particularly damaging is if separate franchisees using lots of different law firms or advisors advising separate things to what potentially a central message might be, is going to increase the risk from a brand damage perspective, because we are going to see a significantly higher volume of litigation when the ERB properly takes effect come the end of next year. So it's worth thinking about. 2025 is very much that planning year of thinking, okay, what do we think the risks and benefits are of that helpful, hands-off or directive franchisor? And if we do want to be fairly directive or helpful, what can we put in place to signpost people to?
Great. Thank you very much. I think we're 1 minute over time, but thank you everyone for listening. Thank you, Sarah.
Thank
Thank you,
you.
Alex.
Thank you all.
Thanks, guys.